Ms. Marinos, I'm actually hoping to take advantage of your keen legal mind today. I'm wondering if I could ask you a few questions about the safety valve provisions. And specifically, do you agree that Parliament enacts mandatory minimum penalties to set a clear floor for sentencing? Like, that's the purpose of it?
Well, I think that there are two objectives. I think that we would all agree that the mandatory minimums are there to signal Parliament's denunciation of the severity of these crimes. And I think that we all want to see those mandatory minimums pass constitutional scrutiny. So I think that Parliament has to strike the right balance.
That's a very good explanation of it. And in terms of the safety valve, that's going to allow a judge to go below the floor if in the circumstances, and it's in the circumstances, the judge decides that the minimum punishment would amount to cruel and unusual punishment for that offender. So it allows for that balance to be struck in any specific individual situation that is in front of the court. Is that correct?
Yes, I would read it that way, that the judge has the discretion with this safety valve to give a sentence that is less than the mandatory minimum if the Section 12 Charter threshold is met.
And it's based on the circumstances of the offender.
Yes, that's my understanding.
And that's the only factor that's laid out in the section. It's the circumstances of the offender are the only criteria that are laid out. Is that correct?
Well, in the safety valve, yes, but I think that in every case the judge is taking all sentencing provisions and discretion into account. Right,
and the only circumstance where the nature of the crime comes up as a consideration is in those exceptions that are in the section, which basically amount to circumstances of murder and treason. Is that right?
Those are the circumstances, yes.
Yep, but not the impact on the victim of the crime.
Well, the impact on the victim is always considered in sentencing when the victim has an opportunity to do their victim impact statement. And of course, the judge is always balancing other considerations, mitigating factors, aggravating factors, what the crimes involve. They're always doing that balancing act.
But not through this section.
No, but there are other sections in the criminal code, obviously, that provide for that.
And there's no limit on how much lower than the mandatory minimum the judge can go, is there?
Not according to this legislation, no.
So if we have two accused that are convicted of, call it kidnapping with a firearm, which has a 5-year mandatory minimum, and equal participation in the crime, but different personal circumstances, then the judge could theoretically give one of them a 6-month sentence and the other one a 6-year sentence if the judge decided that the circumstances of one of the offenders warranted it.
Sentencing is, as you know, an individual exercise. So yes,
that's why
there's a range. There's a range, but and I'm not a criminal prosecutor. I should add that caveat. But yes, presumably there's the possibility of getting 2 different sentences.
Right, but there is the principle of parity, and so if you're looking at that kind of situation, because if let me put it to you this way, if the Supreme Court of Canada can use reasonable hypotheticals, then I've just laid out a reasonable hypothetical. You could have personal circumstances of the accused, and my question for you is, how do you think we explain that to the victim?
I think it's really hard because when you look at the jurisprudence on mandatory minimums, for the most part, the court is not striking down the mandatory minimums for the specific offender. They're striking down the legislation for the reasonable hypothetical. And, reasonable people can disagree. I was an intervener in Senville. Interveners don't have the right to take a position on the outcome. If you ask me my personal opinion, I would be siding with the dissent on that particular case. Is a reasonable hypothetical reasonable? Sometimes it is, sometimes it isn't. there's 5 people who think one hypothetical is reasonable and 4 people that don't.
But if you're looking at it from the perspective of the victim,
Yes.
then where you're at in this particular scenario is that the 2 accused have participated equally. They have the impact on the victim is the same.
That's right.
And yet the court is going to put the interests of one of those accused ahead of the interest of the victims.
In Sunville, I always took the court back to the fact that we were dealing with hundreds and hundreds of images of mostly little girls aged 3 to 10 that these 2 accused had. And explaining to those victims, and what I said to the Supreme Court of Canada was that these are not victimless crimes. We may not know who these children are. They have names, but they're unidentified. They are often unidentifiable, but it doesn't mean that they're victimless. So I completely agree that it would be very difficult to explain why this decision was, struck down. But there you have it.
Thank you.
Thank you, Ms. Kronos. Next, we have Mr. Housefather.